Now, basically, we're talking about the estate planning options. What are some of the options in terms of estate planning at this point?
Well, there's basically 7 basic types of estate plans. So the first one is to have no plan whatsoever, which is actually having a plan, whether you realize that or not. The second is to gift away your property. The third is to jointly own your property with someone. The fourth is to pass your property through a beneficiary designation, like in a life insurance or a retirement plan. The fifth is to pass through a will. And then the sixth is basically revocable trust planning. So that's typically what we see as the 6 major ones. And then the 7th is to do a combination of one of those 6, right, or multiple of those 6, I should say.
So let's talk about the do nothing approach first of all, because I've got a lot of clients that just want to put everything off until they're dead, basically, and that happens more times than you would know. So anyway,
we also have a lot of clients that want
right.
to do nothing, and in our office, we refer to that as the ostrich approach. What I'd rather do is stick my head in the sand and just not worry about it and let my kids worry about it. That is potentially the worst plan you could ever make. And here's the reason why. All 50 states have an intestacy statute. Dying intestate means that you've died without a will. So if you die without a will, there's a statute that says who's going to inherit your stuff. And I don't know about your experience, Jay, with legislatures, but sometimes they don't make the best decisions, and they don't always do what I would want them to do. And so what we find a lot of times is for folks who die without a will, there's a lot of unintended consequences, and it doesn't pass the way they want it to pass or the way they think it will pass. And so by doing nothing, you've defaulted to whatever that state statute says. And every state is different about what their state statute says.
Well, not only that, but just from an emotional standpoint, for that client's beneficiaries, it's horrible. Because here those beneficiaries are in a situation where it's a highly emotional situation anyway, and they don't have clear direction in terms of what they're supposed to do with things. And it is a chaotic mess, and it is just absolutely a crumbling emotional experience for those beneficiaries. So yeah, it's a horrible thing. So then of course, let's go into problems and examples.
Okay. Well, let's start with kind of the pros and cons of doing the no will approach. The pro is that you don't have to do anything, that you literally do nothing, and so it takes none of your time. You don't have to think about it, and you don't have to worry about it. And that is the only pro for the approach, because everything else is a con. So the first con is that the statutory scheme is generally not what clients want it to be, and so who they want to end up with their stuff usually is not the case. The second is that they have abdicated control over their assets and control over who the executor of their estate would be, and they've given that power to the probate court. So the probate court judge has all the power and no direction, and so now they, without really any limits whatsoever, can do whatever they want. And so we've seen in situations like this, kids who you would never give your checkbook to have control of every one of your assets. Or maybe an extended family member that is the one that steps up, but is also the one that you wouldn't trust with 2 nickels, much less your entire estate. And they're the one that gets appointed. The third typical con to this approach is when you described it as a mess, it's not just a mess for the beneficiaries of the estate, it's a mess for the attorney.
Yeah.
So when you make things a mess for the attorney and the court, what you make them is expensive for your heirs. And so, if you want someone else to be in total control, if you want somebody else to decide who your beneficiaries are, and you want to make it as expensive as possible, then you should definitely recommend that you have no will, because you're going to do that. You're going to fulfill all of those objectives.
Right.
And there are a lot of problems that come up with intestacy because of the statutory scheme. So we have a lot of people who end up with those unintended consequences. So let me tell you about one client that we had. So Irv and Sylvia are married, and it is the second marriage for both of them. They don't have children together, but he had children from a previous marriage. So he passes away. Now, they've been married for a long time. They've been married for close to 20 years, and they have a house, but it was Irv's house before they got married. So it's Irv's separate property, okay? So let's talk about what Texas law does, because like I said, every state's intestacy law is different. But if we were to bring Irv out of the grave and we were to ask Irv, what is it that you want to have happen with your house? I would bet dollars to donuts that Irv would say, I want Sylvia to have the house. I want the house to be hers. Under Texas intestacy law, guess who inherits the house?
The kids.
Not quite. Sylvia gets a third of the house,
That's right.
and the kids get 2/3 of the house. Now, Sylvia gets a life estate in the house, and so she gets to stay there as long as she's living. But let me tell you what the kids get to do. The kids get to drive by the house and look at the condition of the roof and see the gutters kind of falling down and the paint's kind of peeling, and so they get to call Sylvia whenever they want and hassle her about the condition of the house. That's really what the net result is. And so what it's become is the house has become a source of conflict between Irv's kids and Irv's wife. And that is the enduring legacy that he left in that situation. That's not the legacy that I would want to leave. And that's not the legacy that any CFP should want their clients to have.
Exactly. Well, and then, of course, the next step is gift the property away. So tell us about that.
So lots of people think, well, what I'm going to do is I'm going to get to the end of my life and I'm just going to give everything away, and so I won't own anything, and so we won't have to go through probate. So this is a strategy that can work. I've seen it work, but it's in general not a good strategy. So the pro of the strategy is it's quick and it's easy. If you give something to someone and it gets out of your hands and into their hands, there's no probate that's required for that.
Right.
You don't have to write anything necessarily down. I mean, if you gifted a piece of real estate away, you might have to do a deed or something like that. But if you gave, all of your household furnishings to your child, you wouldn't necessarily have to paper that in some way. Gifting is a good strategy when you do it underneath the gift tax annual exclusion limit. Everyone has the ability right now under current IRS regulation or code to give up to $14,000 a year to anyone that they want,
right,
without paying gift taxes on it. So gifting can be a very effective way of passing money to kids or grandkids and doing it in a tax-free way. And so those are the two pros about it. Now there's several cons. One is it has to be done during your lifetime. You can't gift after your death. Once you die, anything you have left becomes the subject of your estate. So gifting works really well if you own a crystal ball and you can tell me exactly when you're going to die. And if you don't have a crystal ball and you can't tell me exactly when you're going to die, then it's really hard to ensure that you're going to gift everything away during your lifetime. At least I find that hard to do. Another con is that once you gift something away, it's not yours anymore. You have no rights over it, and you don't have any control over it. So if I decide I want to get rid of my estate, and so what I want to do is I want to write a check for everything that I own to Jay. Well, if I need something in the future, do I have control over all of my money? No. Jay, you've got it.
Right.
If I, let's say I get sick and I have to go into long-term care, and I need that money back so I can get it paid for, so I can pay for my nursing home care. Jay, you might want to go buy a Lamborghini with the money that I gave you. You may not want to buy my nursing home care anymore. But I am totally dependent and reliant on you to give what I gave you back in order to provide for myself in the future. I love you, Jay, but I'm not doing that. The other problem with a gift is that anything over that $14,000 limit is subject to gift tax. So if you give something over the gift tax annual exclusion, the amount that is over that gift tax is going to be subject to gift taxes. And gift taxes are at a really high rate. So for most people, the gifts that they give end up being, 40% gift tax. And that's a pretty onerous rate
Right.
compared to what most people are paying in income tax. Kind of the unintended consequence of gift taxes or making gifts is that often the gifts end up in a very unexpected hand. And this is what we see a lot of times when people are giving gifts as kind of their estate plan. They don't think multi-generationally. They just think about the person that they're giving it to, but they don't think about who that's ultimately going to end up in. So those tend to all be problems. You want to hear an example of a problem that happened with gifting?
Always. I love examples.
So we had a client who bought a house, and the house was worth, well, he bought it a long time ago, 30, 40 years ago. And so the house at that time was worth $50,000, I think is what he paid for it. Well, now the house is worth about $300,000. So what he does is he says, this is not in consultation with me, but he says, I'm just going to give it all away. And I'm going to give it to my daughter because my daughter will take care of me in the future. And so I don't have any problems, so I'm just going to give it to her. So Robert gives the house away to his daughter, Judy. So the first unintended consequence, which Robert didn't find out about for several years, is that because he was over the gift tax annual exclusion, which at that time was $10,000, he owes gift taxes on everything above that $10,000 limit. Now that's not judged at his basis in the house. It's not judged at what he bought the house for. It's judged at what the fair market value of the house was at the time that the gift was made. So Robert, the giver of the gift, not Judy, the recipient of the gift, but the giver of the gift is the one that owes gift taxes. Robert's gift tax was based on $250,000. So he owes gift taxes on $250,000. Now, if Robert was really wealthy, that might not necessarily be a problem, except for a couple of things. One, he didn't fill out any gift tax returns, so now there's penalties and interest that have to be applied to that. The second is, the house was pretty much what he owned. And so now Robert doesn't really have anything to pay the gift taxes with. So you've got that problem. So it gets kind of worse. So the next year, Judy decides that she's going to sell the house. So she sells the house for $310,000. Now, if Robert had passed away and Judy had inherited the house, she would have gotten what's called a step up in basis.
Right.
So when Judy went to sell the house for $310,000, her basis in the house, had it passed through a will or trust after Robert's death, would have been $300,000 because that was the fair market value at the time of death. So Judy's capital gains on the house would have only been $10,000. $310,000 minus $300,000. And so she would have owed a very, very, very small portion of taxes. In fact, I think it would have come out to about $1,800 or so. because of the way that she obtained the house during his lifetime as a gift, when she goes to sell the house, her basis is the same as his basis. So when she sold the house for the $310,000,
Double taxes
she got taxed at the for capital gains
on the basis.
on the difference
The
between
original basis.
310,000 and 50,000.
Wow.
And so she owes capital gains taxes on 260,000.
The government loves that family.
The government loves that
loves
family. Because Robert got nailed for the gift taxes on the pretty much the full amount, and then Judy got nailed for capital gains taxes on pretty much the full amount.
Wow.
So it was a great day if you were the IRS.
Mm-hmm.
It was a bad day if you were Robert and Judy. And so we see that a lot when people are doing gifts. They don't know about the gift tax annual exclusion amount, so they don't know about the $14,000 limit. And they're just giving stuff away, and they think, well, if I give it to the kids, there's nothing owed. And so the lack of knowledge is a real problem. The second is the unintended consequences. And then the third is they don't think about the loss in step-up in basis if they had passed it at death.
Huge red flag. Anytime one of your clients says, I'm going to gift something to one of my kids or to whomever, make sure that before they do that, they check with their CPA or their estate planning attorney. Big red flag right there, gang. Just to let you know.